Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. We appreciate you being here this morning. We'll take just a few minutes before we get started and talk about our process and procedure, and then we will begin with the oral arguments. First of all, as you gentlemen are aware of, the first case waived oral argument late yesterday afternoon, so we're down to 3 cases rather than 4. I'm sure everybody understands how this operates, but I feel compelled to say it as well. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. And the way you do that is to request that from the court after you've come up to the podium and introduced yourself, but before you begin your oral argument. Obviously, the appellee gets no rebuttal time. In order to aid the attorneys, we have a lighting system on the podium. We believe it to be rather straightforward. There are 3 lights on the podium: green, yellow, and red. As long as the light's green, you got plenty of time. Once the light turns yellow, you are running out of time, and once the light turns red, you are out of time. So we ask that you please respect those time constraints. A word of, I don't know if it's caution or what it may be, but I want everyone to understand that these arguments are being live streamed. Once we start, it's going out over the internet. So think about what you're saying before you say it, because you don't get a do-over here. Once it's said, it's gone. Or as Judge Clement referred to yesterday, it's like trying to put the toothpaste back in the tube after it's out. So please be mindful of that. Your panel this morning consists of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before?
No, Your Honor.
Who you got sitting there beside you, Miss Angie?
This is Claire Gordon.
This is Claire's maiden voyage, and she's going to be calling the cases today, so we'll try to act right for her. You may call the first case, Miss Claire.
Jeffrey L. Roberts versus Barry Lynn Carter et al.
All right, gentlemen.
May it please the court, I'm Larry Hicks. I represent Mr. Roberts. This was an automobile accident.
Text, you want to reserve any rebuttal time?
I don't, Your Honor.
All right, sir. You may proceed then. I'm sorry.
No, that's fine. This was a result of an automobile accident that occurred on February the 6th, 2019. It was a one-car accident on Blackberry Road in Benton County. There was a really, really large washout where a culvert was, and the truck completely went into the washout. It was about 9 o'clock one evening. Mr. Roberts, who ran a restaurant there on Kentucky Lake at Beaver Dam, he was at home. He was called. They was running low of bread. He's going to Walmart's to get some bread for the business. And at the time that he left his house, it was not raining, and it had been raining that day. It was not raining when he left. He went down to the railroad underpass. It was flooded. It would later be shown by affidavit of Mr. Billy Castlow, that this large pond, an acre and a half, 2 acres, that had washed through the levee of Blackberry Road, ends up going down to Timothy Drive, which is by the underpass. The defendants had an expert, Mr. Drumwright. Mr. Roberts had an expert, Mr. Guerin, and there were numerous depositions and affidavits and interrogatories filed in this case, which showed that the County of Benton owned, controlled, and maintained Blackberry Road. The proof also showed that Mr. Carter was the road superintendent, had noticed erosion on previous occasion. He had only put riprap on the road. And Mr. Guerin, plaintiff's expert, testified this was like putting a Band-Aid on a broken bone, that there should have been some remedial action taken. And even Mr. Drumwright, the defendant's expert, acknowledged that.
As I understood the facts, it was that the erosion was on the outlet end of the culvert?
It was on the outlet end.
And that's where you put the riprap, but the erosion actually, I mean, the washout occurred on the inlet end of the culvert.
That was disputed, Your Honor, please. Mr. Guerin testified that it would not make any difference where he noticed the erosion on the outlet end or the inlet end, because the water's going to come through the inlet end. You're probably going to see erosion on the outlet end, but once the erosion starts, that water's going to keep seeping through. We're talking about a pond that's 6 feet deep, according to Mr. Castello. The bank's already saturated, and Mr. Guerin testified that it would make no difference if the erosion had been noticed on the inlet end or the outlet end, because as the water goes through, the levee is going to be washed out the outlet end and just keep eating through there. And he said it wasn't a matter, Mr. Guerin said it wasn't a matter of if, but when that culvert was going to be blown out. There wasn't any debris collector on it. There wasn't any head walls. The culvert was too small. The bank of the pond served as a roadway for Blackberry Road. It's like a levee.
So is the question about how it was initially, how it was constructed in terms of about the head walls and whatnot, is that discretionary type of issue?
I don't think that would necessarily be a discretionary issue under 29-2203 and 29-2204 based on the case law, because and we brought this action pursuant to 29-2203, and in the case of let me find it. Under the case of Swafford versus City of Chattanooga, which is a Court of Appeals decision in 1987, discretionary function does not apply to actions under TCA 29-2203 or 29-2204. But even to answer your question maybe a little bit more directly, in the case of Bowers versus City of Chattanooga, that's a 1992 Supreme Court case. The court held that acts that implement policies and procedures are seen as operational and not discretionary. So once they had made a decision to build Blackberry Road, or they also had the duty to maintain Blackberry Road, and that's where the notice came in, where he saw the erosion and Mr. Roberts had made complaints. And I know the defendant's arguing there's no record of complaints, but the reason there's no record, Mr. Teresa Shobes, who keeps up with all the complaints and reports for the highway department, said they're discarded after a day or two, so they don't keep any records of maintenance or reports.
Let me go back and follow up on something Judge Golden asked you.
Right.
So you're saying it's a disputed fact as where the erosion occurred, or you're saying it doesn't make any difference where the erosion occurred?
It doesn't make any difference where the erosion occurred, according to Tate Guerin, Your Honor.
Okay.
He said that it would make no difference whether you notice the erosion on the inlet end or the outlet end. That once you discover erosion, that riprap is not going to take care of it, because they already had riprap there. And
well, I'm just trying to determine if they're disputed material facts.
that is a disputed material fact for sure, Your Honor,
Okay.
based on his deposition testimony. And I'm sure Your Honors have read all this, but Mr. Carter, the superintendent, where this had washed out, he had a 48-inch culvert there on the lot that he put in, and according to Mr. King, who had been on the highway committee, said, you know, they should have known there's gonna be trouble with a levee for a road and a metal pipe. It's gonna deteriorate, and even the defendant's expert said he had noticed rust and deterioration on that pipe, and he acknowledged that erosion had been found. And so when he put in the 48-inch pipe, he put it in a low point. No one, even their expert said he didn't know where the pipe had been located, obviously, when I took his deposition. He said nobody would put the pipe up on the side of the road. Mr. Cashlow said that water always came up to the bottom of the pipe, except in droughts, it's covered. And he said it was only 12 to 18 inches from the top of the surface of Blackberry Road. But when they put in, after this washout, Mr. Carter put in a 48-inch pipe. At the lowest point, it drained. Mr. Carter initially had said he didn't know what inch pipe it was, and then he said, well, I think it was a 36-inch. But the testimony was that that was too small of a pipe. There wasn't a debris collector. There's no head walls. You've already seen erosion. You already had complaints from Mr. Roberts. Ms. Flowers said he may have made complaints, I just don't remember. Said, I do remember him coming down here and making a complaint, but I don't, and we needed to do something, repair something. I don't remember what it was, but I do know it was before February the 6th of 2019. So there is an acknowledgement that Mr. Roberts had went, not only just called, but actually went to the highway department to make these complaints. And then as far as comparative fault, this is something that the court brought up on its own. It wasn't included in the original motion of summary judgment filed by the defendants, but as far as the doctrine of comparative fault, the court wanted us to address that, which we did. And according to Mr. Roberts, when he left his home, it wasn't raining. He turned and went down a hill before this washout. And he said the view of the road wasn't obscured, but there, when he abruptly fell in, he couldn't, in this large hole, very large, the truck completely goes down in it, and the front of the truck hits the bank on the other side, very deep, very wide. But in any event, there wasn't any negligence on his part. We contend there was a bursted water line, and Trooper Flannery put in his report that the view of the washout was obscured by a large water line that was burst and was spraying up and over the road. Mr. Roberts testified that after the fact, of course, he couldn't get out of the vehicle. He's paralyzed from the neck down. He couldn't get out of the vehicle, but he could look and see the water then that was coming from that water line that was falling onto the washout that he was in. But you couldn't see it before, and Trooper Flannery put in his report that the driver's view of the washout was obscured by a large broken water line. Mr. Harris, the tow driver, made photographs, and they was submitted to the trial court that showed the water line that night or that morning, the next morning, that was broken. Of course, they had turned the water off then, the city had. Where the water was spraying out, it burst the water line when the levee broke around this culvert that had washed out. And one thing interesting, Mr. Carter, the superintendent, and this is another thing, I think the witness's credibility in the case law holds this, that a credibility of an interested witness is an issue. Mr. Drumright put in his report that Mr. Carter stated, according to one of the local paper accounts, that Mr. Carter said that there was a breach in the levee there by this culvert during this rain. And by the way, the rain, according to Mr. Guerin from the nearest measuring station, was 1.5 miles away. It was a 3.33-inch rain, which he said was less than a 2-year event. Mr. Drumright had it more, but in his report, he didn't have Benton County. He had other adjacent counties further south and east of Camden. But in any event, when I asked Mr. Carter if he had any idea why that culvert blew out, I just wanted to say, he said, I have no idea, but he'd give the Camden Chronicle, the local paper, his opinion about why it blew out, that the water had risen up on the culvert, caused the washout to occur. So I think you get into a number of credibility issues. Mr. Carter did admit he saw erosion.
Did you impeach him on that issue?
Sir?
Was he impeached on that issue?
I didn't have Mr. Drumwright's report, Your Honor, their expert's report, when I took Mr. Carter's deposition. But I did raise it in my brief. I pointed it out to the trial court, Judge Griffey, in my brief. But Mr. Robert said he did slow down, said he always drives slow in that area because there's a lot of times children around in there, and he's got a young daughter. And he said he slowed down some because it had started raining. And he said he was going maybe 25 miles an hour, perhaps 30 at the most. I think the speed limit there, according to Trooper Philander, is 45, but he wasn't going that fast. So I submit that there wasn't anything that rose to negligence on Mr. Roberts' part. When he left the house, it wasn't raining, and it stopped raining. It wasn't until he turned around and started down the hill that it started raining. And of course, you're just talking about really close right there to where this culvert's washed out at the foot of that hill. But as far as the public duty doctrine, that's been removed, Your Honor, please, by a case of Lawson versus Maryville City Schools, and that was a 12-14-2020 case, Court of Appeals in Knoxville, that held that actions pursuant to 29-2203 are not subject to the public duty doctrine. So if they're not subject to the public duty doctrine, the special exception doctrine wouldn't apply, because that's just an exception to the public duty doctrine. So that wouldn't apply. The discretionary function wouldn't apply according to the case law, Your Honor, please. And the actual or constructive notice pretty much is set forth in some of the case law. Hawks versus City of Westmoreland held that under Tennessee Code Annotated 2204 and 292204 and 292203's analogous, Your Honor, please, were alleged an unsafe, dangerous, and defective highway in this case. They held that constructive notice has been defined by this court as information or knowledge of a fact imputed by law to a person, although he may not actually have it, because he could have discovered the fact by proper diligence, and his situation was such as to cast upon him the duty of inquiring to it, citing Kirby versus Macon.
What is the constructive notice?
I'm sorry,
No, what is the constructive notice? Mr. Carter apparently inspected the culvert. He noticed that there was some erosion on the inland end and attempted to repair it. But how would he have known that there was erosion, that there would have been erosion on the other end?
That once you discover erosion, even their expert admitted this, that puts you on notice to make further inquiry and inspection. And with a saturated bank, and once you discover erosion, under the Tennessee Department of Transportation manual that Mr. Guerin testified to, you have to take some remedial action, because it's not when, not if, but when that culvert's going to blow out. It's a metal culvert, it's deteriorated, it's rusty, you found erosion. They already had riprap on it. Riprap, Mr. Guerin testified, would not be enough. The mayor admitted that the county of Benton did not have a written policy manual on the maintenance of culverts or the maintenance of the road. So Mr. Carter was just kind of playing it by ear, and he should have inquired further as to the erosion. He could have dug it out. He had a 48-inch culvert. He could have put it at the bottom of this levee. He could have drained that pond. It's been dry, no problem. I mean, it was just, that was the notice. Plus, Mr.
Did all of this come out in the proof?
It did.
Is this all in dispute?
It is. It all come out, and it did. And Mr. Guerin testified that, according to Google Earth, he could see where the county had repaired that asphalt right over that culvert, which would indicate subgrade damage, or they went down and tried to repair the culvert. But there's no records of it because the county keeps no records of repairs or maintenance that they do, or even reports of complaints, no record. But you can look at the physical evidence and him admitting erosion. Even Mr. Drumright, their expert, admitted that should have put a reasonable person, prudent person on notice, and they should have done further investigation and took remedial action. All this is in the record. I took numerous depositions, affidavits. There's abundance of proof in the record, Your Honor, please, of what I'm saying.
Let me ask you about your public duty argument. What's your position about the public duty doctrine?
That Lawson versus Maryville City Schools holds that the public duty doctrine does not apply to actions brought pursuant to 292203. They have held that with the enactment of 292203, the General Assembly expressed its clear intent to limit the scope of the public duty doctrine by removing immunity for certain claims, including specifically the claim at issue here. If we were to allow the public duty doctrine to trump 292203, as the defendant argues, this would nullify the clear intent of the General Assembly and render its enactment useless and an absurdity. All claims arising under 292203 necessarily stem from a breach of a duty owed to the public at large rather than a duty owed to a particular individual. For those reasons, we hold that the public duty doctrine does not apply to the claims as stated in the complaint that come under the purview of 292203. Because it would clearly, if you say that immunity is removed for unsafe, dangerous, or defective roads or streets, Your Honor, that's a duty to the public at large, which is covered under the public duty doctrine. You look and see if immunity is removed by statute. In this case, it has been. Then you look and see if the public duty doctrine applies. If the statute, and they assume that the General Assembly knew the state of the law at the time it enacted this statute, it did not make any exception for public duty doctrine, nor did it make any exception for discretionary function.
But you've got to be aware that even where immunity is removed under the GTLA, that there are a host of cases that say that the public duty doctrine may still bar recovery.
It can in certain cases, Your Honor.
You argue it doesn't apply in this type of case.
No, specifically in this case, claims under 292203, it doesn't apply, Your Honor.
Okay. All right.
Mike.
Thank you.
Thank you, sir. You've used your time.
Thank you.
May it please the court, Haynes Russell on behalf of Benton County. Plaintiff here has alleged that Benton County is liable for his injuries suffered as a result of an accident when he ran into a washout in the middle of the night that no one...
Speak into the mic if you would.
I'm sorry. That he ran into a washout.
May need to pull it down a little bit. I know.
Yeah, a little shorter than Mr. Hicks, maybe.
I understand. I know how that works.
When he ran into a washout in the middle of the night. I want to start talking about actual or constructive notice for that.
Well, if you don't mind,
Absolutely.
Judge Armstrong just asked about the public duty doctrine. Let's follow up on that, and then I don't want to take you out of your argument, but just tell me what your position is on that before we get lost in the argument here. Sure.
Our position is that the public duty doctrine is a separate inquiry outside of the GTLA. So since Zell, the court has said that first that it's going to look at the GTLA and determine whether immunity has been removed. Here we argue that it hasn't been, but assuming it has been, the next inquiry is whether or not the public duty doctrine applies. So, and that's been reiterated in Lawson versus Hawkins County It's a different case in the Maryville City Schools, which is a recent Tennessee Supreme Court case where they said, look, the public duty doctrine applies as a separate defense from the GTLA. There was no caveat that it only applies to claims under 205. No court has said that. It applies to, or other than the Maryville City Schools case. And based on the most recent Hawkins County decision, we would say that it still applies to all GTLA claims.
Thank you.
Going to actual or constructive notice, plaintiff can't show actual or constructive notice of any alleged defect to the culvert at issue on Blackberry Road, and that's relevant to plaintiff's claims under 203, 204, and 205. He has to show actual or constructive notice for any of those claims. Here, there's just simply no proof. For actual notice, it's what the county knew, when the county knew it. Plaintiff admitted that we had no notice of the washout prior to it actually washing out.
What about all the proof that counsel just stated was in the record in response to what Judge Golden asked?
About the erosion?
Yeah, about the constructive notice issue.
Yeah, sure. Moving to constructive notice, I think he's kind of going under a passage of time theory that, that you had noticed erosion previously, right, and didn't, and that would have put you on notice of a washout. That under that theory, though, he's got to show how long the dangerous condition existed.
What about the expert? What about the expert testimony? It sounds like that there's a question of whether or not there's a disputed issue of material fact, if as far as his expert's testimony with regard to whether or not his seeing the erosion on the outlet end would have put him on notice that he should have gone further and inspected the inlet end or inspected the culvert generally. I mean, what do you say?
Right. There's two reasons that that's not a genuine issue. First, his expert thought that the erosion was on the inlet end, and that's confirmed in his testimony. He didn't realize it was on the outlet end, so he didn't testify. While he said, well, that could have put them on notice, he was talking because he assumed that it was on the inlet end where the washout actually occurred when it wasn't.
Did he say it wouldn't have made any difference whether it was on the outlet end?
No, he thought it was on the inlet end, and he thought that I don't think that testimony is in the record, Your Honor.
So he didn't testify about the fact about what would have been the situation had it been observed on the outlet end?
Right. He only testified as it related to the inlet end, which is where he thought the erosion had been seen. And it's undisputed it's on the outlet end.
So you would say that the opposing counsel is incorrect in his statement that it didn't make any difference whether it was on the outlet or inlet end?
That's correct.
As long as there was erosion, there was going to be a problem here.
That's correct. And two other notes about that. Mr. Guerin's opinion was really focused on the design of the culvert. His issue was basically saying, look, you can't put riprap over a culvert. That design's defective. You have to do a concrete head wall, apron, and grate. Well, as you pointed out, Judge Golden, that's a discretionary function decision that goes towards the design of the culvert itself that's more appropriate analyzed under 292205. And I'd point the court to Fowler versus City of Memphis, which a plaintiff tried to bring a claim about the design of a culvert under 29203, and the court said no, that's more appropriately analyzed under 205. You can't pigeonhole that into 203.
So is it the county's position then that there was no constructive notice and that the plaintiff's expert didn't support the fact that there was constructive notice?
That is, Your Honor. And for, both because he was mistaken on where the erosion was and also because his opinion is focused on the fact that the design was faulty in his opinion.
And he did not say that it didn't make any difference which end it occurred at. He didn't make that statement.
No. So going back kind of to constructive notice, there's three separate theories that can be proven under the common occurrence theory, the cause of created theory, or the passage of time theory. The common occurrence theory's out. There has been no prior washouts at that spot. And in fact, the testimony is that culvert had been there at least 22 years, as long as Mr. Carter had been at the highway department without any issue. The caused or created theory requires a plaintiff to show the defendant caused or created the alleged dangerous condition. Here, there's no proof in the record that Blackberry Road was originally created by the county. There's no proof in the record that the culvert was originally placed by the county. Regardless, there's no proof that the culvert itself was defective as installed. So the caused or created theory's out, which leaves the passage of time theory. We've already discussed kind of his arguments on the erosion. But again, all of these theories require you to show how long there was a dangerous condition. And I'd also point out, as far as the erosion goes, I'd point to the court to the Mitchell case cited in our brief. There, they had argued the passage of time theory related to an allegedly defective sidewalk. And they argued, well, we have this Google Earth image, right, showing that the sidewalk had been raised for a number of years. And because they had testimony that the sidewalk had been raised a number of years, the plaintiff had argued, well, that's proof of constructive notice of a dangerous condition, and how long that dangerous condition had existed. But the Court of Appeals disagreed and stated that while they had proof that there had been a raised sidewalk for a number of years, there was no proof that that was dangerous. And specifically, the court pointed out in that case that there were no prior accidents and no issues, no complaints about the raised sidewalk. That basically, the plaintiff had just shown, well, there's a difference in height, but that doesn't show there's a problem. So analogous to here.
Is that the first Mitchell opinion?
It's the 2022 Mitchell opinion. I think
there were
it's
two
the
of them there.
first. I believe it's the first.
Okay.
And so the same really goes here as far as the erosion goes, because you can say, well, okay, well, there was water. Mr. Carter testified there was water peeling off the back of the culvert that would have caused the outlet end, so it was kind of eroding from the top. And so he placed additional riprap. He fixed it. But there's also no proof that that was dangerous at that time. There's no proof even really when that was. We know it was a good deal before this incident occurred, and when he looked at the culvert 3 weeks before during his inspection, or he said no more than 3 weeks before, there was no issues that he noted. Plaintiff also, or appellant also discussed rust in the pipe. That can't provide constructive notice. Mr. Drumright, our expert, testified there was minimal deterioration in the pipe that he noticed, and that also that rust can appear quickly, that rust doesn't indicate that the pipe's necessarily deteriorated. And that was reiterated by Mr. Carter, who testified that rust would appear within a year or two after placing a pipe. And yet, you know, the testimony in the record is that these pipes, depending on where they are, can last, 15 to 25 years or more, depending on kind of where that pipe is and how much, traffic it's getting. Plaintiff also pointed out, or appellant also pointed out about water flooding over the road. That testimony is actually related to Rockport Road. It's about page 80 in Mr. Roberts' deposition. He says he made a complaint about water overpassing Rockport Road. There was no testimony that there was any complaint about water overtopping Blackberry Road.
Didn't apply to this road?
Right. The testimony shows that he complained about Rockport Road, which is a nearby road after a culvert was bent, not that he called and complained and said, hey, water's going over Blackberry Road. There's no testimony to that effect.
So it didn't even apply to this road?
That's correct.
Is that from the plaintiff's testimony, or is that from the records of the county highway department?
That's from plaintiff's testimony that he said he called and complained about Rockport Road.
Because it was my understanding there weren't any records kept by the highway department.
Right, so what they do is someone will call in and say, hey, I've got a complaint, this culvert's bent, or whatever it may be, and they write that complaint down, and then they go and fix it. And once it's fixed, they discard the complaint. But everybody testified that they weren't aware of any previous complaints about Blackberry Road over that culvert. and that was from Mr. Carter, Ms. Flowers, who he mentioned. He actually deposed the sheriff who does keep records, and they'll sometimes get road-related complaints, and he had no record of any complaints about Blackberry Road either. Moving to comparative fault, reasonable minds could not differ that plaintiff's degree of fault was greater.
Is it necessary to even get into comparative fault in this issue, in this case?
Not if there's immunity isn't waived under 20203, 204, 205.
So if the court were to find that the trial court got the initial analysis correct, then there's no need to get into the comparative fault analysis.
That's correct. The first inquiry would be whether or not immunity's been waived. Of course, it would go to whether immunity has been waived under a modified comparative fault analysis if the court reached it. And reasonable minds could not differ that his plaintiff's degree of fault was greater than that of defendants, even assuming the defendants were somehow negligent, whether it be the erosion or something else. Plaintiff decided to go down the hill. When he testified, all he could see was rain once he actually lived towards the top of the hill on Blackberry Road. And so he goes out to get bread at 9 o'clock at night. And he encounters so much flooding under the underpass of another road that he has to turn around. He can't travel down it. And instead of stopping and saying, well, there's flooding around, I probably don't need to get bread that bad, he continues down Blackberry Road, which has got a pretty steep hill. He then, as he is at the top of the hill, it begins raining heavily again like it had been all day. The testimony is that it at the very least was around a 2-year rain event with around 3 inches. Other areas of Benton County received over 7 inches that day. And so as he's at the top of the hill near his house, it begins raining heavily again. He says it was raining cats and dogs. All I could see was rain, and he didn't stop at his house. He didn't stop on the road and wait for the rain to subside a little. Instead, he continues down the hill, which he testified was, quote, a black hole under good conditions because of the lack of street lights down there. So he continues down the hill, and as he gets close to the culvert, he testified that, quote, all I could see was water. And whether that be because of the rain or because of a busted pipe, it's undisputed that he had basically no visibility. But he still continued down the hill at 25 to 30 miles an hour without braking or stopping or turning around to go to his house that's, a mile away. And unfortunately, he encountered a washout that no one knew about. And for that reason,
his testimony was that he couldn't see the surface of the roadway.
he testified all I could see was water.
Couldn't see the surface of the roadway.
I don't know if he said what you're saying specifically, but his testimony was that all he could see was water. And then in hindsight, he thought that it was potentially related to the pipe busting off in the air, that basically it was so much water that it had to have been more than rain. But he didn't stop. And, you know, with limited visibility, there could have been anything in the road, whether that had been flooding or, you know, a downed tree with this kind of storm. And unfortunately, he encountered a washout. And for those reasons, we ask that the court affirm the trial court's decision to grant summary judgment. Thank you.
Sir. Appreciate your argument. Gentlemen, we all appreciate your arguments. We will review your brief, review the record, take this matter under advisement, and attempt to get you an opinion at the earliest possible time. Thank you. Thank you, gentlemen. You may be excused. You'd call the next case, please, Miss Claire.
Robert Christopher Walton versus Rebecca Guess